Happy Tuesday. It's time for coffee and Cursey words. I'm so excited. I am ready. It is August 31st. I can't believe it. Tomorrow's September 1st. I'm dying. I can't believe it. We have two quick bits and a very long new motion in the Britney Spears conservatorship. But we're going to talk about some legally legal shit, really legally legal shit with the First Amendment today and how it applies to more than one thing. Because Britney, this motion's based on the First Amendment, but also there's some interesting First Amendment challenges going on around the country that I have been dying to talk about. And we just have been so busy. We have not had time. So we're going to talk about the MILF Mobile and free speech. I can't wait. I am going to laugh. We are going to laugh. But First Amendment's no laughing matter. But sometimes the context is funny. So let me know where you're coming from and what you are drinking. I've got some bulletproof coffee this morning. It is rainy here in Middle Tennessee. We're getting the rain from Ida, not like y'all got down in the Louisiana area, in New Orleans, in Mississippi. So stay safe for all of those that don't have power. I hope that they get that restored soon. I know it is very stressful. I know a lot of people are still evacuated. So stay safe out there in this crazy weather, and let's just have a little fun. Let's have a little fun. It's the world's crazy right now. We're going to have some fun. And I just saw somebody coming in from Transylvania, and I'm not leaving until I pull it up. All right. Tell me where you're coming from and what you're drinking. I'm so excited about this. Let's go.
Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Cursey words. This channel is where the law nerds unite to talk about facts, not fuckery.
You guys are coming in from all over. I see you coming in from Sweden and Canada and all over the US and all over the world. So thank you for being here. As I'm saying, all over the world, y'all blow me away every single coffee and Cursey words. And when I get asked about doing all evening shows, I'm like, no, I know that people are going back to work. I know that, restrictions are changing and COVID is changing and not everyone can watch during the day. But for our international crew, for a lot of y'all, this is the stream that works best. So we are keeping a daytime stream and a nighttime stream always, because I do what I want, because I can. All right. The first thing we need to talk about, let's talk about some quick bits. We have quick bits. The first quick bit, I actually saw that the BBC article, I spoke to a reporter from BBC about Elizabeth Holmes and Theranos. I always want to say Theranos, like Thanos, but it's not. It's Theranos, like diagnose. I get it. But that trial is starting today. We're going to talk about that just real quick. If you're not following the Elizabeth Holmes trial, now is the time to jump into this crazy ass story with both feet. I have an Emily Show episode case brief coming out tomorrow that is short to get everybody up to speed. And then as the trial goes on, we'll be doing some deep dives along with the trial. This is a conspiracy to commit wire fraud and wire fraud trial, which is going to parallel so nicely with the upcoming Jen Shah trial. They are different types of schemes, but the crime is the same. In the Theranos case, it's the basic crime is you were selling investors shit you knew didn't work, and you got like hundreds and hundreds of millions of dollars for it, and you can't do that. Oh, and you use the wires to do it. Everything uses the wires. Look, wire fraud is one of the best friends of federal prosecutors. Wire fraud is so broad. And then when you get that conspiracy bit, you can bring in the communications between Elizabeth Holmes and her former lover, former business partner, Sunny Bhatwani. I'm going to say that wrong. Balwani. And because I don't have my notes up because we were just going to do a quick bit. So with that, they're going to bring in all of their communications. They're going to bring in, the prosecutor's going to bring in the fact that they knew that they were running tests on machines that weren't theirs. She was selling the idea that she had this little machine the size of like a commercial printer that could run all kinds of blood tests on just like a finger stick of blood, not blood coming from your arm. If this were true, if this worked, it would be amazing technology. And Elizabeth Holmes was brilliant at selling the dream. She sold the story. She sold, imagine a world where everyone has early diagnosis, where no one has to say goodbye too soon, where healthcare is a basic human right, where you can go down to your local Walgreens and get diagnosed with anything, where you're not limited by money, where lab tests aren't too expensive. Imagine a world. Yeah, we absolutely want to imagine that world. The thing is, she couldn't do it. She dropped out of college at 19. She had this put on very deep voice and really sold it, and then surrounded herself with people who brought credibility in, and everyone bought what she was selling. And it's fucking fascinating because it's so much money. Jamila hit it on the head. If selling the dream were a person, it's exactly what it is. Everyone wants this to be possible. Everyone wants healthcare to be better. Nobody can figure out how to make that happen, and they keep fighting over it, election cycle after election cycle. But we want people to have access to healthcare that isn't bank breaking. So it's fascinating to see this now coming to trial. And the push pull with her is going to be that, one, she does what everybody else does in Silicon Valley. Everyone sells the dream. That's how startups work. That's how venture capital works. That's how this works. You sell the dream and then you make the dream a reality. The thing is, that might have been what's happening at the beginning, but then she knew the machine didn't work. She sold it into Walgreens anyway and kept selling the dream. So even as they had to change the way testing was happening, she bilked investors with that Walgreens deal, and she knew that they weren't testing blood on her machine. That's, I think, if the prosecution focuses on that, I think that they will have a better time proving that she knew. I wonder how much her defense team will come in with, she believed her own hype to the point that it is actually a mental diagnosis or disorder, but she believed, whether right or wrong, she believed it would work. She did not ever intend to defraud or deceive because she believed it. So I wonder how much pathology or pathology, that's what I'm trying to say, pathology with regard to her mental health. We'll see. A bunch of documents just got unsealed. She might be going kind of a PTSD. The other dude made her do it, pointing at the empty chair route, but I get into that in the podcast tomorrow. So we are absolutely going to be digging into this as the trial moves forward. Jury selection just starts today. Jury selection, they gave it 2 days. I call no. I don't think they're going to get a jury in 2 days. If they get a jury in 2 days, that would be fascinating. But I don't think so. So they're starting jury selection. She's being tried separately from her co-defendant, and we will see. We will see what the defense does with the unsealed documents. I think we're definitely going to go the route of she believed what she was selling, and the reason she believed it is because of what all these other individuals were doing, and it's not her fault. Look, she sold former secretaries of defense and secretaries of state and military personnel and professors. Well, lots of them, not all of them. She sold so many people in this reality. My big question is she going to testify on her own behalf and sell a jury on her story too? Because she sold everyone else. And people love a good story. So we'll see. And that's what I was talking about in the article with BBC today. So I'll link that on the community tab and stuff if you guys are interested. I love sharing what I think about things, especially when it comes to criminal prosecution, but B, I like helping. So when people are like, "Hey, can we talk about this case?" I'm like, "Yes, we can always talk about it." Sarah said, as a current med lab tech student, it's literally not possible. To do, and we have a very long way to go before that would ever be possible. There are some things that they are doing, but even then, 23andMe went through regulatory lawsuits. Ubiome went through regulatory lawsuits. These other companies where you are pinpricking, or finger sticking blood and sending it through the mail, some of those have been through regulatory issues too, but they weren't selling more than they could do, and she was. So Kempire said, I hate to say this, but I kind of think she does believe it. She may. The prosecution has to prove that she intended to defraud, and they have to overcome the defense saying, no, look, this is her pathology. She believed it. And these are her diagnoses, and she believed it. She wasn't dealing with reality. So she couldn't form the intent to defraud because she thought it was real, even though everyone was telling her no. So it's going to be fascinating to see. Tiffany asked, why is he being tried separately? Because the defense won their motions to try them separately. As a prosecutor, that is not an ideal situation. I talk about that in the podcast tomorrow. So we need to get into the First Amendment. I have a First Amendment quick bits, and then we're going to keep going. So let's get into First Amendment quick bits and then into Britney. Or into coffee. We need to get into coffee. So let's talk free speech for just a second. And remembering that free speech is a right guaranteed to us under the First Amendment, freedom of expression. There are other freedoms in there, freedom to assemble, freedom of the press, freedom of religion. These are things that the government cannot infringe on you. The government can't say, hey, you can't say that shit. The government shouldn't go to Twitter and be like, hey, take these people off of Twitter. They can't say that shit. Twitter's not a government agency. Twitter can regulate free shit all they want. But there is a free speech case going on in Maine over a personalized license plate. And the personalized license plate says tits out. Like actually, let's just go to the film. Let's just go to the article. Tits out. It is the MILF-mobile. It talks about how many kids are in the car, and the sticker, we'll go to Reddit in a second because Reddit has all of the info on this. It says, however many kids in this bitch, honk if one falls out. Like, it is caution, this vehicle makes sudden stops at your mom's house. Like, it's just so wild. So the MILF-mobile tits out license plate is in court because Maine is trying to take away the license plate. So these are some of the other license plates that Maine is not happy with. Yeah, crazy bitch. Come on now. If somebody wants to be crazy bitch on their license plate, let them. Oh my God, shut the fuck up. This is a brilliant license plate. I love it. Fat ass, who gets to decide if that's offensive? Maybe they're just trying to be body positive. Fuck this, Maine. Come on, lots of fucks. Fuck you, fuck yeah, people suck. How is that not just a statement of fact? I also like fuck you too, but I don't think they mean you too. I think they're actually disparaging the band U2. Maybe they just really hate, you know how some people like really hate the Beatles? Maybe they just really hate U2. Maybe somebody broke up with them while they were listening to Joshua Tree. I don't know. Maybe they just hate U2. On my way to fuck your bitch. Who figured out that was what that stood for? Because I would not be driving down the street going, oh, clearly that's what that means. Sober AF. Again, I think AF should be allowed. I do. Some of you in the chat are like, yeah, I absolutely hate you too. Remember when Apple put U2 on your phones? I do remember. Maybe that's why they were so mad. Fuck yeah. Fuck you. Later bitch, which I actually think is quirky and kind of funny. I don't find that offensive at all. Sure, let people have a butt fuck license plate. And you know what? Again, if there was a comma here, maybe that license plate means but fuck. Like, come on, man. Maybe that doesn't mean BUTT. Maybe that means BUT, comma, like, um, I think that I eat ass is probably just advertising, you know? I don't know if this is offensive to everyone, maybe to some. You're you're a dink is fantastic. I just I just I'm fucking late. Where's I'm fucking raking? I'm fucking raking needs a license plate. Well, maybe not in Maine. Maine's not allowing it, but I'm fucking late. That would be me all the time. All the time. All the time. Dink is a super Maine word. Thank you, Audrey, for that. Yeah, these I don't think are offensive. I think, look, asshole, again, this is just letting you know. The asshole and the crazy bitch ones, they're just letting you know. You know what you're signing up for if you have to deal with that person on the road. They're just letting you know. And also, I don't give a fuck. Advertising, advertising. Oh my God, shut the fuck up is life advice. I don't find any. I mean, how did anyone decide that that said cunt monkey? I just, I just. Anyway, so I just thought that these were kind of hilarious. And then the MILF-mobile photo, I think, is in this same post. So let's pull this up. This is a better photo of the MILF-mobile. The, if you're gonna ride my ass, at least pull my hair. Condoms prevent minivans. Only gay cops give me tickets. I can see why people would find that offensive, but also everything else about the car, some might find offensive. Sun stops at your mom's house, tits out. So they are fighting the First Amendment right to say what the fuck you want to say on your license plate. And this is not just playing out in Maine. There are other states fighting over this. This is actually also going on in Tennessee. There are more. We're going to go to Reddit real quick because they had more pictures of the MILF-mobile and they were fantastic. Thank you, Reddit. So I don't know. I don't understand what the shitbox thing is about, but that's because I'm old. I think it's funny that she has penis on her. Like, I was in the car line yesterday, parked for quite a while. Some of you who are on Instagram saw my Instagram live where I was parked waiting for pickup. Can you imagine being behind this car at pickup? It just, I feel like I would be amused. I don't know if everyone would be amused. But if you're going to ride my ass, at least pull my hair. I would get a giggle out of this car if it was parked in front of me at the pickup line. I don't know how the kids would feel once they're old enough to realize that the minivan that picks them up has penis written on the side of it. I imagine rolling up to a junior high with that would probably be detrimental to your child because junior high school kids are assholes. But I just think it's kind of funny, but the state of Maine thinks that it's offensive. And that's one of the things about free speech is the government. This is the government limiting speech because the government issues the license plates, right? So where are the boundaries of the government regulating speech and what is offensive? So I'm going to be keeping an eye on Maine. This is the one that's going on in Nashville, where a woman is suing the state over a license plate that was deemed offensive 10 years after she bought the license plate. She says that the license plate 69 WNDU is to relate to her interest in astronomy and gaming, and that the license plate means her birth year, 69, with a common gaming term written on the license plate as pawn, referencing the term pond used when a gamer totally owns another gamer. So, yeah, that's 69 pond you. That's what is in this lawsuit, that it's the birth year and a gaming term from 10 years ago that is now being deemed offensive. And yeah, I'm going to be keeping an eye on this one too. These two, Maine and the MILF-mobile and 69 pawn in Nashville, I'm fascinated by. I can't wait to see what the courts do with them. But there are boundaries to speech, and offensive speech goes under. There's actually a legal test for this. We're going to talk about it real quick, and then we're going to move on to Britney. But there is actually case law that kind of lays out what is offensive. And we even got into this a little bit in different contexts with the Nirvana Big Baby, because is it CP? Is it obscenity? Is it problematic? And this comes in with this too. Is it art? Does it push the boundaries? Is it offensive? What are you allowed to say? What are you not allowed to say? And so under the Miller test for obscenity, just so we're all on the same page, it's whether an average person applying contemporary adult community standards finds the matter taken as a whole appeals to the Puritan interest. And we saw this in the Nirvana case too, which means that it is erotic, lascivious, abnormal, unhealthy, degrading, shameful, or a morbid interest in nudity. I don't know why the Miller test went to morbid interest in nudity, sex. But like, people like sex, though. I don't know why we're all pretending that people don't. It's just crazy. And then it goes on to whether the average person applying contemporary community standards finds that the matter depicts or describes sexual conduct in a patently offensive way. So that's where you're going to get people arguing over some of the other license plate, whether it's describing sexual conduct in an offensive way, and whether a reasonable person finds the matter taken as a whole lacks literary, artistic, political, or scientific value. That's for obscenity. But in the speech realm, it's also going to be, is this valid speech or is this not? And how is tits out offensive under that? It's body positive. B, it should be looked at as gender neutral. Humans have tits. Why does it have to be offensive? Who is sexualizing it over at the DMV? Anyway, the state of Maine clearly is lacking a sense of humor. I expected better. Like, people seem happy in Maine. All the lobster in the world, happy cows making ice cream, and well, the weather can be kind of rough, but why? Why so mad? Why so mad, Maine? So a little bit on the First Amendment and offensive speech. This keeps going on and on and on. But I will say, for those of you in Rhode Island, if you're in Rhode Island, anyone in Rhode Island in the chat, just put an RI in the chat and let me know. Judges in Rhode Island overruled the ban on offensive license plate and said it was free speech and it was appropriate, and that license plates are part of the First Amendment, and there's very limited things that they can restrict, mostly hate speech. So Rhode Island has it down. Rhode Island was like, we're not doing this. California, on the other hand, is trying to reject quite a lot of vanity plates. And California, I've had multiple vanity plates in California. I have some back here. California will actually write to you and ask. Well, they used to. I don't know if they still do. We'll write to you and be like, what is the meaning of this? So with regard to my license plate, where is it? I have a DMB WHS license plate up there. Dave Matthews Band Warehouse. But I was asked more than once, and if you remember, I think I told this story in one of our members only live streams, that I was asked if it stood for dumb whores. And I was like, no, it stands for Dave Matthews Band Warehouse. Why? What? But yes, I was asked on more than one occasion if my license plate stood for dumb whores. No, it doesn't. I mean, I would be supportive of that, but I got it to say Dave Matthews Band Warehouse. And for the Dave heads, not only is it an amazing song, but it's also the fan association. So, should we get to Britney? Shall we get to Britney? We've talked about license plates and dumb whores and tits out and all the things, but I think the DMB WHS, I will put in the chat what it looks like. It just looks like this. You can picture it. It means Dave Matthews Band Warehouse. And since it's not my license plate anymore, I can talk about it. I am going to be getting a personalized plate now that we are in Tennessee and settled. But where they make the personalized plates was damaged in the tornado. So when we moved, we couldn't get personalized plates and we had to change our plates, you know, the first thing you do when you move out of California is like rip your plates off your car as you're going across the state line. So that you're like, no, that's not us. La 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 la. I noticed that the Texans that have moved to the area do not rip their state license plates off as quickly as the Californians that are moving into the area. But that is just my observation. We will be following the MILFmobile Kate. I think it's a perfect thing for quick bits. We will be following the First Amendment and personalized license plates because it deeply impacts all of us. I like it when somebody's license plate makes me laugh. I appreciate it. If I saw somebody's license plate that said OMG, STFU, I would bust out laughing. It would kind of make my day. I'd be like, you're right. Most of the time I feel the same way. And God, everything has just gotten way too serious. Way too serious. Sandy says, my issued plate starts with MFR. That's amazing. Look here, motherfucker. Do you guys watch the TikTok creator who talks about Tales from the ER, whose name I'm going to completely forget? Because the problem with TikTok is I know the content because TikTok creators tend to make the same version of their content, and I know their content, but I don't know their names. The ER, the guy who does, look here, motherfucker, we're trying to save your life. So funny. But yes, when I saw MFR, I was like, yep, that. All right. Let's get to Britney. Brandy's like, I love that. Same. He's hilarious. Same, right? We all watch the same stuff. We're on the same page. We're all on the same page. I love the tips from the ER. It's really funny. I loved the 4th of July ones. It's like, don't blow your hand off. So funny. All right. I will find who I'm thinking of. And if one of you guys find it, and I will, yes, thank you. I will link it down below because when creators make me smile, look, this is what I go on social media for. I go on social media to laugh. I absolutely love it. So yes, thank you for shouting it out, Tiffany. I appreciate it. We'll link it down below too. All right, let's go talk about, are you guys ready to talk about this new Britney motion? It's 244 pages long. We're not going page by page. Just so you know, we're not going page by page. The mods are like, thank you to everyone. Thank you to everyone for not going page by page. This was filed on August 26th. For USA Today, but I think it just populated in the system yesterday because I didn't see anyone talking about it until yesterday. And by the end of the day, after I had a very long day, when I went to go look for it, it sure was there. Now, the LA County document system will sometimes populate a day later, same day later, 3 days later. Like they don't always pop up on the public access. You have to obviously sign up for them and pay for them, but it doesn't always pop up where you can download them contemporaneous to when they were filed. But this was also not filed until 9:56 p.m. So it would make sense that this would not necessarily populate until Monday. So let's get into this. This is filed as a associated party in that USA Today wants to have reporters at the next hearing on September 29th. The court, remember, terminated the remote audio access program, like not just for Britney's case. So after the June 23rd hearing, when audio of Britney leaked everywhere, the entire LA County Superior Court system said, we're not doing this anymore. You can come to court in person. COVID's not a thing. We're not doing remote audio attendance anymore. And remote audio was just for the audience to listen to court proceedings. It's different than LA Court Connect. LA Court Connect allows witnesses, participants or litigants, defendants, and lawyers to liaise and connect with the court and be on Zoom calls and interact with the court and the judge and each other. Remote audio, the remote audio access was just to literally listen in to what was going on in court. And it crashed multiple times during the June 23rd hearing. I was able to get into it towards the end. I know there were lots who weren't able to get into it, and we're happy that proceeding had been recorded. The problem is that was illegal. The judge advised against it a million times, and then hyperbole. And then when the court found out, I think the court found out it was being streamed, or was being streamed and recorded. And the court's like, shut down the RAA. And then the next day, the entire LA Superior Court system shut it down. So the argument from USA Today is that this is a imposition on the First Amendment rights, and that there should be access to these court proceedings, and that access through remote audio makes it more accessible. This is filed by Christopher Melcher. You guys might recognize that name. He does legal commentary on podcasts, on YouTube channels, on Twitter, under CA Divorce Attorney, has represented celebrities in divorce and things like that, and is the attorney for USA Today in this context, because he is working for a firm, Watzler Metchler, but so that indicates to me he's not in-house counsel for USA Today, but they're outside counsel that they've hired to deal with this petition. So this is a petition from USA Today and their parent company. I actually quite like USA Today. And they are petitioning for access. Media requests for order restoring remote audio access program and or providing links to LA Court Connect. Here's the thing. I'm just going to make a disclaimer now. I want this to happen so badly. I really like the remote audio access program. I thought it was convenient. Look, I am in Tennessee. It was really nice to be able to just use kind of a remote court call to get in there and listen. I appreciated it because that I could appear as a member of the public. Look, when I had to appear on court call for my cases and people would be blathering on forever about nonsense when the court was just going to set a date, and they would be like, I would be like, look, I've been on here for 2 hours. I would just like my next date so that I can move on with my life. There would be days I would be on the phone for like 3 hours to just get a next date. It's just court call can slowly drain your life. I never thought in my life when I stopped doing court appearances and court calls that I would be so excited to do it, but I was. The thing is, I don't think this is going to fly. I want this to work. My gut is that this is not going to work. Also, it is not Judge Penny's decision to reinstate the LA County Superior Court's remote audio access program. The site judge, the head judge of the county court system did it. I don't know if they also petitioned the head of the LA County courts system. And I'll have to see if they name, I absolutely forget who the presiding judge is right now. But these decisions are made much higher up than Judge Penny. Now, Judge Penny might have called up that and just been like, this is not working. And then they're like, oh, well, we were going to be getting rid of it anyway. So I don't know if this will fly. That doesn't mean I don't want it to happen. This also benefits me. I like being able to listen to these recordings. Having to have someone on the ground in LA get to court early, get in line, get a seat in the courtroom, still social distance, and be able to report on these cases is difficult. But it's not impossible. The courts are still open. So there's a balance there. Just know that when I point out the things in this case that might fly, it's because we talk about facts, not fuckery. But that doesn't mean I don't want it to be so. I want it to work. Legally, I'm not sure that it is going to work. So let's go through the memorandums of points and authorities, the declaration of Maria. I want to say Pugnete, but that is not what that says. It is though, isn't it? Of Maria Pugnete. Damn it. I'm going to say this wrong. And it's going to be offensive to someone. Request for judicial notice. So we're going to go through all of it. Let's just jump into it. Table of authorities, lots of authorities. The Los Angeles County Superior Court. The Los Angeles Superior Court allowed the public and media to listen to non-confidential proceedings in its courthouses live through the Remote Audio Attendance Program, RAAP, the RAP. But RAP was, see, Nadia, this is what I was trying not to say. I was trying not to say it wrong. Thank you guys for all of the pronunciation keys. I'm going to say it wrong no matter what. Ponte, Puente. We can do that. You're like Puente, Emily, Puente. Stop reading it to be wrong. Get it together. We try. Thank you, everybody, for when Emily gets things wrong. The chat is so great. I appreciate you. Pronunciation is hard. So this was a program that started really with COVID. I don't think this existed before COVID, but before COVID, I wasn't trying to access court hearings that weren't mine. And with mine, I just used Court Call, and that was before LA Court Connect had started, because LA Court Connect brought the video component to it. So they canceled the program a day after a few people broke the rule against recording. Well, we don't really know how many people broke the rule, but it definitely seemed like it was a few. Not only was it recorded and re-uploaded, but it was also being streamed live, which at the time I said, this is not going to go well, because I was on RAAP when the judge was so angry that that she was notified that this was being recorded or streamed. And the judge had just come off of complaining, questioning the attorneys about how confidential documents got into the hands of the New York Times. So the judge was already mad about the security and the privacy of these proceedings, even though they are open proceedings, but the rules being followed, sealed documents remaining sealed, etc. They say that the court now requires in-person attendance for the public and media to monitor and report on what happens in court, while granting video and audio access to parties, counsel, witnesses, and others through LA Court Connect. Now, court is required to be open. I think the court's argument would be, the court is open. You are welcome to walk in. I think there is an argument that because of COVID, it's not always that easy. Not everybody can just come to court, but the courtrooms are open and they have overflow courtrooms. So I think that the court's argument on this is going to be no. At least when people come into court, we can see what you are doing. We can make sure that cell phones are not out, that people are taking notes on pen and paper, that people aren't live tweeting and things like that. But there's less control when it's over RAAP, which people have to sign up for to have access, but it's not as controlled as a bailiff in a courtroom looking at the people and what they are doing, or the parties that are signed up with the court, who the court has their names, addresses, phone numbers, and all of that being able to access the court through LA Court Connect. They say that the termination of the RAAP program infringes on the right of free speech and fails to provide equal protection under the law by taking away the right of the public and media to observe court proceedings remotely, but affording others the right to do so, which is interesting because it really is arguing, look, if the lawyers can access court, if the parties can access court by LA Court Connect, then why can't the media and the public access court by LA Court Connect? I imagine the court's going to say, because y'all blew it. This is why we can't have nice things. They're saying that the court created two classes, one that can access courts remotely and another which cannot. Because the public and media have a constitutional right to access non-confidential court proceedings, the court must establish that terminating RAAP was necessary to protect a compelling government interest. And the court, who will probably just deny this and not respond, the court, though we'll see, the court would say, I imagine, again, just playing devil's advocate on this motion, that the compelling government interest is protecting the rules of the court, and you can't record court when you're in court. If you're going to record court proceedings, you have to apply with the court and be granted permission to record proceedings. In the Britney Spears case, that permission has never been granted, and they come flooding in before court hearings from every media outlet you can name, requests to photograph, requests to record, requests to stream, and they're always denied. So the court's going to argue that having the RAAP program up doesn't allow the court to enforce its own orders, because if the court denies people.com or TMZ's right to record proceedings or stream proceedings, but then somebody on RAAP just goes ahead and violates the court order and does it, and the court can't enforce that, that's an enforceable government interest. Not that I'm thinking that that's a better way to do it, but I'm imagining That is exactly how that argument would go because I worked for judges. I can see where the thinking on both sides of this is. I appreciate though that they brought it, that USA Today spent the money to hire counsel to bring this to say, no, you are closing people out of this proceeding. And what we need in this particular case more than any is transparency in the courts. And you're taking away that transparency. Also, I forgot, and we're like 40 minutes in. You guys don't forget to do the YouTubey things, like the likey, subscribey things. And if you're not subscribed, subscribe. If you are subscribed, just make sure YouTube hasn't helpfully unsubscribed you, and like the video so the algorithm can find it. And share it with a friend who wants to know about what this motion says. All right, let's keep going. The court's desire to prevent recording of its public proceedings is important, but not compelling. Right. They're going to say it's compelling because the court could sanction someone who's in court violating their rules, but it's very hard for them to sanction someone they can't find on the internet. Though they could then have you sign up, but people will sign up with spoof emails and phone numbers and stuff anyway. The concern over recording does not override the need for transparency. It's paramount that public trust and confidence be maintained in the judicial system by allowing the public and media to observe the proceedings firsthand. The argument will be, then come to court. Less restrictive means were available. The court could have issued additional warnings or punished the violators if they could have found the violators. And the court did issue numerous warnings, but I understand the court. But when the court says, don't record, don't recreate, and people take photos, recreate diagrams, that's not this case. Record, stream. How does the court expend the resources to go track down people over the internet who were granted access to do this and then violated the court's rules? The court could have issued additional rulings, punish the violators, but eliminating the program for all members of the public and media, but eliminated the program for all members of the media and public instead. The risk of recording remains because those who use LACC are just as capable of recording the proceedings as members of the public and the media. They are, but they're easier to track down. There are limited seats in the courtroom. We're still in a pandemic. Both solid arguments. Media outlets across the world are covering this story and other important cases in the LA Superior Court, and they cannot send reporters to watch every case in person. The court's going to be like, so? Especially those like USA Today, which is based outside of California. Even if the media had the budget to send reporters in person to these hearings, the court does not have the room, and there are health risks during the pandemic. By taking away remote access and limiting public and media access in-person courtroom attendance, the court is given preference to those who it allows to use LACC and to local media outlets who can send reporters in person. The disparate treatment is an unconstitutional infringement of the rights and the public. So you're treating people differently based on access. And that is one of the underlying issues with equal protection, right? You don't treat people differently, though there are lots of circumstances where you do. Anna said, court's response, that sounds like a you problem, not an us problem. Yeah. That's, I think, what the court will say. Relief requested. Let us in, let us in, let us in. Restore RAAP. Look, it was there. It's gone. Restore it. It existed. You can do it again. Provide a link to LA Court Connect for a limited number of public and media to observe the proceedings and all non-confidential court proceedings throughout the Superior Court of LA County, subject to Rule 1.150 of the California Rules of Court, which prohibits recording or broadcasting of proceedings without court approval. The number of links may be determined by the court to its technical capacity and should be honored on a first-come, first-served basis. The thing is, then the court clerk, who might not have the time, the court clerk then has to field all of the requests and send out all of the links. And that becomes a staffing issue. To which the media would say to the court, that is a you problem, not an us problem. At a minimum, remote access without recording or broadcasting is requested through RAAP and LACC. The reason they specify without recording or broadcasting is because the court has routinely denied those requests for literally like everything. And they come in every single hearing. So September 29th, the court will be addressing the petition to suspend or remove James Spears. Don't we all want to know? Let me tell you how bummed I am that I will be in LA on the 29th and cannot be in court because I will be at a conference. But yes, I'm very interested to see what happens on the 29th. I am going to be riveted. The hearing of the 12th accounting and any final account. Yes. How much are the lawyers getting paid? We all want to know. Request for security for conservator Jody Montgomery. I bet you that's already been dealt with. Any other petition authority or appointment hearings set for 9/29 not closed to the public and continued hearings on such matters. I believe that the other ones that exist are dealing with my brain, making Jody Montgomery the permanent conservator of the person and not the temporary conservator. I believe that's still on the docket. Statement of facts. The court announced the creation of the RAAP program effective January 11th, 2021, as a way for attorneys and members of the public, including the news media, to listen remotely to non-confidential court proceedings through the LA County Superior Court using the court's new RAAP notice to attorneys 1/11/2021. So yes, created during the pandemic. The notice said the program was part of its effort to ensure public access during the pandemic due to social distancing requirements in courthouses. They should just have left it. Another program, LACC, allows remote video and audio access to court. LACC provides video and audio services for remote appearances. That means for people who need to appear in court who are part of the actual proceedings. Access is provided for remote proceedings. The court has waived the $15 cost recovery fee starting September 7th. The court made clear that LACC was not for the public and media because that access was provided through RAPP. LA Court Connect is not available for use by the news media or general public. Spectators, anyone without a role in the hearing, may participate via RAPP, which enables users with a smartphone, tablet, or computer to listen with internet service and establish a remote connection. On June 23rd, Britney Spears made a statement in court during a hearing regarding the probate conservatorship over her person and estate. The court allowed the public and media to listen. The court warned that recording was prohibited. The court became aware during the hearing that someone had recorded Ms. Spears' statements and advised. And this is towards the end of the hearing because I was on the RAAP during this. It was after they took the break. I understand that there has been an issue with RAAP, that apparently someone was recording the proceedings in violation of the order that I made this morning. So we're going to shut RAAP down right now. So please disable the RAAP immediately. That's also very concerning because I specifically said that there was not supposed to be any recordings, and that happened nonetheless. So I want counsel and Ms. Spears to be aware of that. So I made an order this morning that there was not to be any recording, and somebody, and I don't know whether it's one person or more than one person, violated the order. When it said cut RAAP immediately, literally the line went dead. And then the rest of this is from the transcript that they attached. The court has not identified who was responsible. It's unknown whether the recording occurred by someone on RAAP or LACC. Well, the court said it was someone on RAAP, but I understand the fact that RAAP was streamed might indicate that it was not the lawyers. I understand the argument, but there are some surrounding factors. But can one say for sure? Probably not, and that is their argument. The following day, the court eliminated RAAP for literally the whole fucking county. The news release announced a general order rescinding social distancing requirements in all county courthouses and quoted the presiding judge that LACC will remain a staple in our court in the future, offering less expensive and convenient alternatives to in-person appearances. The statement continued. Effective June 28th, the court will no longer offer RAAP to listen remotely to courtroom proceedings. The court implemented this temporary. Now it's temporary. It didn't say that when it was released. This temporary program during the pandemic, recognizing there may be abuses of the court's orders prohibiting recording, filming, and distribution of proceedings. Widespread breaches by the public in a recent court proceeding. This is why we can't have nice things. highlighted the need to return to in-person open courtroom proceedings, which is a welcome development. Not for everyone. I am sad. So again, I said it when it all came out. I was frustrated that people would record because there would be backlash. That hearing was the 23rd, and on the 20, what was this? The 24th in the afternoon, the entire court system was like negative Ghost Rider. The pattern is full. The next hearing was July 14th, 2021. There were 18 attorneys, parties, and interested persons on record for the hearing, all of whom appeared via LACC or telephone per the transcript, except for 3. The interested persons are not members of the public. It's Lynn Spears, etc. This included several participants who are not parties or counsel for parties, such as Amanda Goad and Zoe Brennan Crone, attorneys for the ACLU of Southern California. Well, they had filed a motion that was on calendar for that day. The ACLU was allowed remote access to the proceedings because it wanted to argue its amicus that Ms. Spears should be afforded the right to counsel. The court denied the proposal. The ACLU did not represent Ms. Spears and was not granted leave to appear as amicus curiae. You know, as they're arguing this, I just wonder if, because they've made this motion, if this motion gets set for the 29th, at least USA Today has a legitimate argument that their lawyer must be on the call, and a member of USA Today must be on the call for the 29th, because if the court's going to rule on this, then they have a reason, just like the ACLU had a reason to be present on the 14th, which is very clever. They said that the ACLU had no greater standing to participate than other members of the public. True, but they had filed a motion, so, they're going to say they did. The court also permitted Kevin Cawley to use LACC, who is identified in the transcripts as attorney for an unidentified person of interest. Not one of Lynn Spears's attorneys, by the way, but there are other persons of interest in this case, including like KFED, but I don't know who Kevin Cawley belongs to. All right, we're scooting up. There is intense interest in this case. It goes on with media outlets worldwide covering it. We know multiple requests have been made for media coverage from the beginning of this action, which have been summarily denied the same day. Oh yeah, all of them. All of them. He attaches a whole bunch of them, which I appreciate. But yeah, every time I see them, I pull them up and I'm like, oh, another media request denied. It's just every single media request is denied to record, photograph, broadcast, etc. The next hearing, September 29th, which could draw greater attention, because of the ongoing allegations of conservatorship abuse by Mr. Spears and her pending request to remove him. Reporters from outlets based outside of LA, like USA Today, cannot easily send reporters to view proceedings in person. I don't think that's going to be persuasive to the court. I want it to be. I am persuaded. I want it to be. But the court's going to be like, you're USA Today. Get somebody in LA. Not our problem. But I understand the argument. Relying on court transcripts or records is not adequate because of the delay in receiving those documents. Oh my God, I feel that so hard. Look, trying to rely on somebody else's interpretation of what was said in court is awful, because you have to rely on how they process information and what they think are the most important parts. And for every single person that's watching this story, there are different things that they pick up on. And so it is very difficult to take someone else's reporting or recollection of it and go, oh, this is the full picture. And often that's what we have to do if you cannot attend the proceedings. But it was so nice to get to hear it on the 23rd, because then you can interpret it for yourself and share it with those that you either report to or, like me, give commentary to, without it being filtered through somebody else's kind of lens of how they see things. It could take 2 weeks to obtain a transcript on a rush basis. Although court documents are usually posted the next business day after filing, they are not a substitute for attending the proceeding. Accurate. Direct observation of the proceedings, whether in person or through remote access, allows the public and media to understand and report on the demeanor of witnesses and provide context to the proceedings. Agreed. Agreed with all of that. On August 16th, 2021, the Judicial Council of California issued a report on the importance of remote access, recommending that all courts expand and maximize remote access on a permanent basis. Sorry, my throat. On a permanent basis for most court proceedings, and should not roll back the increased access to courts made possible by remote technology to pre-pandemic levels of in-person operations. Cover letter by the Chief Justice of California. The report quotes a statement by the Chief Justice from 2013 that court, quote, access should be physical, remote, and equal. Per the report, remote access to the courts can increase equity, fairness, transparency for both the public and the media. The need for more remote access to the courts is likely to increase significantly in the coming months as California pursues more equity and inclusion initiatives and works to manage the anticipated rise in evictions. So, allowing people, and this is not just Court Connect, because with regard to that specific concern for eviction cases, individuals will still be able to use Court Connect. They're individuals involved in the case. They aren't going to have to find, childcare, drive to court, find parking, pay $30 for parking, get through security, get to court, wait for their case to be called. Court days are long days. Getting into court is a long process, especially in LA. Getting into an elevator in the Compton courthouse can take you 25 minutes. So that can be not only intimidating for members of the public who don't do it all the time, but sometimes it is not practical. And then people don't have access to their rights. I think remote access to the courts is absolutely essential. I also think it will help people going forward to preserve their rights because it won't cost as much for lawyers to appear in court. A lawyer's not going to have to drive to LA in the morning and then out to Pomona with regard to California. I know there are areas of Texas where you can't get from one court to another court that's on the same circuit in the same day driving. So it will allow attorneys to be more efficient because they can appear in more courts without spending drive time that they're billing their clients for. And it can bring the cost of protecting your rights legally down, which means more people can go, you know what? I can stand up for myself in court. And also, I can understand what's happening in court. I think a lot of the misunderstandings of our court process, not the willful misunderstandings, not the person on Instagram who's like, I don't care what the court says. I don't care what the law says. I disagree. I'm like, okay, well, there's no help for that. That cannot be helped. But for those who want to understand and go, this seems wrong. Why is it this way? And what needs to change? Then having access to different court hearings and hearing how it proceeds and observing how court works can really help bridge the gap of understanding, since so much of American life plays out in fucking litigation. We love litigation. So, if we're going to continue to be, one lawyer for all up in here, might as well make the courts accessible. Okay, I'm going to stop ranting about this because I agree. I don't know if this will be persuasive to the courts, but I agree that the courts need to be more accessible and should be. I also get really pissed when people don't follow the rules and we end up in this situation. If people hadn't streamed and recorded, then our AAP probably wouldn't have been shut down in the first place. So to those people, I understand the desire to do the thing and get it out on YouTube, but also now we're here. It's like the teacher who went to school unvaccinated and sick with symptoms and exposed her entire class and a whole bunch of people got sick. Look, just don't do it. You ruin it for everybody. Just, if you're sick, stay home. Why is this hard? Oh my God. All right. I'm going to go on a rant about common sense. I'm going to rein myself in. We are going to go back to the First Amendment and access to the courts, which is critically important to protect people's God-given civil liberties under the Constitution. Not just constitutionally given. These are inalienable rights, they say. Court access for all. I'll stop ranting now. I agree with court access for all. They go on to say that the benefits of remote access are discussed in the report. The reduction in the number of individuals who have to travel to courthouses reduced traffic and air pollution. Also a very California concern, because getting from where I lived to court in downtown could take me 2 hours. It was 16 miles. It was 16 miles. So I started taking Vermont. Yeah, but so difficult to get to work. And we'll continue to have a positive climate impact going forward. Remote proceedings allow pro bono attorneys and legal aid providers to serve more clients with greater efficiency, increase transparency, and access to court proceedings for the public and the media. The Judicial Council recommended that the courts should expand and maximize. We've already been through that. The First Amendment and the California Constitution provide a right for the public and media to attend non-confidential court proceedings, including probate conservatorship cases. The First Amendment to the U.S. Constitution, which applies to states through the 14th Amendment, there was a lot of court cases about that. Like, does the First Amendment apply to the Lawnard rant? Does the First Amendment only apply to the federal government? Does it not? Does it apply to the states? Because the First Amendment as written applies to the federal government. The 14th Amendment is what expands it. Thank you for coming to Con Law today. Good to see everybody. And provides that Congress shall make no law abridging the freedom of speech, press, the right of people peaceably to assemble, etc. The California Constitution provides a more protective, definitive, and inclusive we're going to drop the A on that, provides more protective, definitive, and inclusive rights of expression of speech than its federal counterpart, which state constitutions can do. State constitutions can grant you more rights from the government infringing on your business. They cannot grant you less rights than the federal constitution, which is why I think we're seeing a population shift from states to states, because the states can do more, but they cannot do less. And not all states are created equal. We know that. We know this to be true. A law may not restrain or abridge liberty of speech or press. The people have the right to instruct their representatives, petition government for redress and grievances, and this is just going through the California Constitution. A qualified right of access exists for public and media to attend certain governmental proceedings. This right extends beyond the context of criminal proceedings and encompasses civil proceedings as well. They continue to go through the different codes of civil procedure, saying, because again, you can't just say we have a right to attend court. This is the part of the motion where they are laying out the law that says that, because you can't just say things. You have to then back it up with facts. These are the facts. We know the facts to be true. But again, you can't just be like, Your Honor, we all know this. They have laid out very well all of the different cases and laws and rules that establish the right in California for access to the courts. We're going to keep going. Any closure of probate proceedings other than for confidential matters would not pass the historical tradition utility test. They go through the Supreme Court in the NBC subsidiary case, talking about probate cases that allow the public to be a part of probate proceedings, that probate proceedings themselves are not considered confidential unless there are parts of the proceedings made confidential. And they go through the case law that illustrates that. They argue that termination of the RAAP program violated the free speech rights of the public and media under our federal and state constitutions. They quote Globe newspaper versus Superior Court, where the state attempts to deny the right of access in order to inhibit the disclosure of sensitive information. It must be shown that the denial is necessitated by a compelling government interest, and it is narrowly tailored to serve that interest, meaning least restrictive means, right? So could it be argued that better technology, better tracking, punishing those who record is a less restrictive means than just axing the entire program? Absolutely. Will it be persuasive? I worry that it won't, but it's a good argument. And again, I'm glad to see a media outlet stepping up, because USA Today is fighting this fight not just for USA Today, right? If RAAP is reinstated, this benefits me, this benefits everyone else on YouTube, this benefits other media outlets who can attend remotely as well. So I would be interested to see if other outlets will join this motion and kind of start litigating this through the California courts, because it's not just this case. California has lots of high profile cases, and arguing for access and for continued access, and then to deal with the technology to trace people if they are the ones that have recorded or released information. They go on to talk about the Supreme Court case of Waller versus Georgia, which identified 4 elements to justify exclusion from public for a court proceeding. One being the existence of an overriding interest likely to be prejudiced absent the closure. 2, the closure is narrowly tailored, no broader than necessary. And again, the argument that the complete termination of this program is broader than necessary is well taken. No reasonable alternatives to closing the proceeding are available. Again, technology makes punishing those who do things that are outside the court, outside of what the court ordered, possible. Whether the court chooses to pursue that or not is up to the court. 4, the trial court must make findings adequate to support the closure. Now, I can see Judge Penny saying, not my circus, not my monkeys. This goes to the presiding judge. And the PJ made this decision. When I say PJ, I mean presiding judge, not pajamas. The PJ made this decision. And because of that, this needs to go to them. And the PJ needs to rule on this because they're the ones who have the authority over the program, not me as kind of a line judge in this probate court. So I can see that argument coming too, that this is not the right court to take this up on because Judge Penny can't undo this, though it seems that Judge Penny and what happened in Judge Penny's court was probably instrumental in this happening. They say findings are also required by the California Constitution to support state action limiting court access. A statute, court order, or other authority adopted after the effective date of this subdivision that limits the right to access shall be adopted with findings demonstrating the interest protected by the limitation and the need for protecting that interest. So it's not just a, hey, come in person. It's more, they're asking for more findings to be made. When the court canceled RAAP, the news release stated it was a temporary program during the pandemic, and widespread breaches by the public in a recent court proceeding highlighted the need to return to in-person open courtroom proceedings, which is a welcome development. To the extent that these are findings, the court stated its governmental interest in enforcing the rule against recording and broadcasting court proceedings. I think that's absolutely right. And noted the program was intended to be temporary during the pandemic, but the court did not explain how cancellation of the entire program due to violations in one case and during one proceeding was necessary to protect the interest. This is not this narrowly construed, right? This is not the least restrictive means necessary. This is literally fuck it, shut it all down instead of trying to deal with the one issue. And the argument here is that that does not adhere to what the case law clearly requires. No finding was made that the recording occurred by one of the RAAP listeners, rather than one of the 15 participants on Court Call or LA Connect, nor did the court explain why the elimination of social distancing measures for courthouses necessitated the discontinuation of RAAP. I think it was their substitute. Like, look, there's still access, it's just different access. They go on to argue there's no compelling government interest that exists in preventing the recording or broadcasting of public proceedings. Now we're just attacking the heart of the thing. Like, fuck it. Let's just go for the heart of the dragon. You know what, Your Honor? You've denied everybody for 13 years the right to record these proceedings. But why? But why are proceedings not recorded? Why aren't we allowed to stream what goes on in the courtroom? Why not? I could see in a criminal trial, if it's being streamed, when parties go to the bench, you might want to say, hey, we'll cut away. But we've seen in other trials, when parties go to the bench, you still get to hear it because the jury's out of earshot and the jury's not supposed to be watching the media. So you can't even argue that, well, it could potentially affect the jury pool. No, transparency is transparency. I like this argument. I like where we're going. I don't know if it's going to work, but it's got to start somewhere. Might as well, USA Today is like, might as well be us. Fuck it, let's go. We ride. I love the we ride attitude of this USA Today motion. I'm here for it. The court rule regarding broadcasting and recording of proceedings states the governmental interest, quote, the judiciary is responsible for ensuring the fair and equal administration of justice. The judiciary, pronunciation's hard today. The judiciary adjudicates controversies, both civil and criminal, in accordance with the established legal procedures in the calmness and solemnity of the courtroom. Although the government has an interest in the orderly administration of justice, that interest is not absolute. A, quote, clear and present danger, don't we love that quote? Don't we love it? A clear and present danger must be shown to prohibit the exercise of free speech rights, which the U.S. Supreme Court described in Pennycamp versus Florida, which is a 1946 case. When we say the case law is old and it builds from there, Pennycamp is an old case. But none of this says that recording upsets the calmness or solemnity of the courtroom. I have seen a lot of things upset the calmness and solemnity of the courtroom. Sometimes it's counsel, sometimes it's parties, sometimes it's the audience, sometimes it's the judge. Sometimes it's my cell phone ringing with Khalees's My Milkshakes Bring All the Boys to the Yard in the middle of a dead silent and fully packed preliminary courtroom. But Judge Andrews was like, the look, it was that slow. I was sitting there and I was digging for my phone as it was like, my milkshakes bring all the boys to the yard. And my echoes in this courtroom. And the judge is like, and just stared at me. And I was like, I'm so sorry. I thought I turned it off. It was like 3 days later when one of the defense attorneys' phone went off, and it was Miley Cyrus, Party in the USA. And the attorney looked at the judge and was like, my kids keep changing my ringtone. And also upset the solemnity of the courtroom. But I digress. That doesn't justify a blanket ban on ever recording court procedures, but generally you have to apply for recording in a courthouse. Sometimes it is for safety, but with the Britney case, people know who the lawyers are. They know who the participants are. You're not worried about witness safety in a high profile case. You're not worried about these things. And even if you are, people can still walk into the courtroom and look at people. Now, this said, recording includes like sketch artists. They have to be approved as well. Pennycamp versus Florida gives us the proposition that whether the threat to the impartial and orderly administration of justice must be a clear and present or a grave and immediate danger, a real and substantial threat, one which is close and direct, and one which disturbs the court's sense of fairness, depends upon a choice of words. Under any one of these phrases, reviewing courts are brought in cases of this type to appraise the comment on a balance between the desirability of free discussion and the necessity for fair adjudication, free from its interruption of its processes. And though I think that in days past, and certainly in 1946, there is an argument that recording court proceedings would have been greatly disruptive. Trying to change out film rolls on a film camera is a whole lot different than somebody doing this with the volume on silence. Like, that is a whole different experience. Technology has changed, and we are working with case law from the 40s to determine if these things are disruptive to court proceedings. And I would argue that technology has made it so, as I forget to pull this up, technology has made it so that these things are not so disturbing to court proceedings any further. And that's what they're arguing here. And I think they are arguing a bigger issue. While this battle might not be won in the Britney case before September 29th, this does raise a good issue that the premise upon which the LA County Superior Court system regularly denies access might no longer be a valid premise. And I am living for that. There is no blanket prohibition in the California Rules of Court against recording and broadcasting of non-confidential court proceedings. Rule 1.150 states that these activities may be permitted as circumscribed in the rule if executed in a manner that ensures the fairness and dignity of the proceedings are not adversely affected. So just record it all. Don't cut it down and make it look some way it's not. Just record it all. This rule does not create a presumption
for or against granting permission to photograph, record, or broadcast court proceedings. Because the law is neutral on whether to grant or deny permission to record and broadcast, it cannot be said that the government has a compelling interest in preventing that activity. I love this argument so much. The interest is legitimate and substantial, but does not override the right of access. Concerns about recording confidential court proceedings do not exist here because the court may exclude the public and media from having remote access to any portion of the hearing that's confidential, just as it would to close the courtroom, leaving no risk of recording. And that does happen. If you're in a hearing and part of the hearing is confidential, you just boot everybody out and shut the doors and be like, we'll come back. Stay in the hall. We'll come back for you when we're ready for you. That regularly happens. And you could do that with this technology as well. You could just mute it until it comes back on. The Judicial Council report on remote access states the government interest in providing transparency to the public and media of its operations and encourages courts to continue providing remote access even after the pandemic is over. These statements contradict the statements made when RAPP was canceled about returning to pre-pandemic conditions and removing remote access because of the recording without assessing the competing and overriding need for transparency. They go on to argue that eliminating RAAP was overbroad. I agree. Just axing the entire program is not the narrowly tailored relief that one would like to see. It's just like, once again, fuck it, we're out is not narrowly tailored specific relief. The judge presiding over the hearing may have been justified in turning off RAAP access during the proceeding when it learned of the rule violation, so it could prevent further recording until it could investigate the matter. The subsequent abolishment of the program was an overreaction. I don't disagree. The court was not justified in removing remote access to the public and media while maintaining that privilege for parties, counsel, witnesses, and others. Denying the public and media the right to remote access in proceedings through RAAP in all cases based on one incident punished the public and media for misconduct that might have been caused by participation on LACC, right? Because they're saying nobody said where the recording came from, which feed it came from. And I don't know if the LA Superior Court even has the ability to track that down, or the technological means to track that down. They go on to say that when a recording or broadcast is made of public proceedings in violation of Rule 1.150, the court may punish the offenders. That is constitutionally permissible because the state action is content neutral. So it's not that they're punishing you for speech, they're punishing you for violating the rule, and that would apply to anyone equally. If the government's aim was to prevent recording, it did not accomplish it by abolishing the program. The risk of illegal recording still exists, even with those attending in person. True. It's just easier to suss out. Therefore, denying remote access does not address the evils that the court's trying to address. They continue on to say the right of the public and media to equal protection under our federal and state constitution was denied by terminating remote access to them while affording that right to other participants, being the participants in the court proceeding, not just the court and not the media and general public. So everyone within the system is allowed in the system, and everyone not within the system is kept out. Going through this argument as I soliloquy real quick and remind you to do the YouTubey things, do the YouTubey things. Like, subscribe to stuff. I always find that it helps when I say that and remind people. So thank you. I wonder if the court, by court I mean the Judge Penny, I wonder if Judge Penny's feet being consistently held to the fire on this is going to start to show why these proceedings were closed. There are many that have concerns about the neutrality of Judge Penny in this, that, you know, at least since 2019, Britney made a plea to the court saying, this is abusive. What are you doing? And then we've seen other denials of motions that benefit her father, the conservator of the estate. So there are lots of questions about it. Having the members of the media and public attend every single proceeding to see the consistency or inconsistency of the ruling, to hear the arguments of the party, to hear how the judge is persuaded, to even hear how the judge addresses one party versus the other, you can tell
If the judge is annoyed with a party, if the judge finds an argument well taken, you can absolutely, particularly if you listen to a lot of court proceedings or if you've been on the receiving end of a grumpy judge, you can tell. And so it allows the public a lot more insight, and it allows the media a lot more insight to question, particularly this case, but all cases, what the fuck is even going on here? And I feel like this is the beginning of an ongoing battle with this, to get access to Britney's proceedings and have them continue to be as open as they were. But it also raises the question, is recording the thing that the judge is the most afraid of? Is it? Like, let me know what you think in the comments or in the chat. Is recording really what the judge is worried? Is that really, really, really what the judge is worried about? I have questions. I have questions. I have questions. The California Constitution expressly prohibits the denial of equal protection under the laws and prevents special privileges or immunities to protect particular citizens of classes. I like the other argument more than the equal protection. I understand the equal protection argument. I understand it for sure. So they go through the equal protection analysis, saying that when the court terminated the program, it created two classes of access: one for parties, counsel, and witnesses who are allowed to attend remotely, and the other for the public and media, saying, y'all have to figure it out, but this group can just be part of it, inside and outside. Eliminating RAAP infringes on the fundamental interests of the public and media to access court proceedings and provides privileges and immunities to a particular class to the exclusion of others similarly situated. I wonder what the court will do with similarly situated, or if there will be an argument that no, they're not similarly situated because the participants in a proceeding are the participants. They have a different purpose than observers. So observers are like, and some observers are not being treated different than others. Participants and observers are not in the same class. Also, I moved my camera and it's driving me crazy. It keeps just shifting slightly and then like this hand disappears. It's making me nuts. It happens when I turn off my camera that it gets shifted. There we go. Emily, why does your background noise look different? Well, every time I shut off my camera and adjust it, it moves more that way. All right, now we're back. It was literally making me crazy. They're saying that the court must demonstrate why its cancellation of remote access to the public and media, while it preserves remote access for others, is necessary to serve a compelling state interest. I appreciate the argument. I think making the court delineate what they're doing makes sense, and making the court actually make a ruling, actually make a finding, actually say more than, this was temporary, it's gone now, bye-bye, 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 bye-bye. All right, we're going to go through, we know what the equal protection argument is. We've gone through the other arguments, the First Amendment free speech argument. They're saying that media outlets are now burdened. I don't think this is going to be persuasive to the court. I don't think the court cares. Media outlets are now burdened by having to send a reporter to Los Angeles to view the proceedings in person, which creates an unnecessary expense and a health risk. That's more persuasive to the reporter and the public due to the pandemic, especially for those based outside of California, like USA Today. By comparison, remote access is provided to other participants through LACC for free starting September 7th, 2021. I think that the health risk is the more persuasive. The expense, maybe not. We'll see what the court does. You got to put it all in. No problem with that. Request for findings. Due to the importance of the issue raised by the request, I think it's a great request. I think it's well written. I think it sets up a battle between the media and the courts. And I think that that's a battle I want to see had. Get it. Get it. Get it. The court should state its reasons and any finding of fact to support its denial or relief. And when the court does that, it sets up the ability of people to then challenge those findings and to continue fighting. USA Today requests that the court grant relief, as stated. Then there's the declaration of Maria. Just gonna go with that. Maria Puente. I am trying, y'all. I am trying. And the thing is, I know a lot of people with the last name Puente. It's still hard for me to read. The U throws me off. Um, as an entertainment reporter for USA Today, I regularly cover high profile court cases. That must be the most fun job ever. I'm based in Virginia and follow several cases simultaneously throughout the country. There's intense and ongoing public interest in the Britney Spears conservatorship. Media outlets worldwide report on case developments. A Google search for Britney Spears conservatorship on August 19th, 2021 returned 35.4 billion results. Wow. Including 7 million news stories. Remote access was allowed by the court for the hearing June 23rd, 2021, which enabled USA Today to report on the statements Ms. Spears made. No remote access was permitted for the media on July 14th. To cover the hearing, a reporter from USA Today appeared in person and arrived early to ensure a seat would be available. Accurate. I am informed and believed court permitted no electronic devices to be used. I believe that as well. So that the reporter had to use a pen and paper to take notes and wait for a break to dictate to USA Today editors what happened in court. Accurate. It was like old school, like running back out and like trying to like voice record things and then running back in. I received those notes for my reporting. The process was slow, expensive, inconvenient, and provided less information than was available when RA was provided prior to the hearing. To accurately report on court proceedings requires observation by the reporter in person or through remote means. I agree. Or a reliable source who knows what occurred. Reviewing file documents. Recording file documents and transcripts is important, but does not replace the experience of listening to the hearing. Agreed. They don't tell the whole story. Even these documents are available. They don't tell the whole story. The demeanor of witnesses, the tone of voice of the judicial officer, we talked about that, and other subtleties cannot be gleaned from a document. It can only be done through observing the proceeding in person or remotely. And the court's going to be like, you're welcome to come here. You're welcome to come here. When remote access is available, my preference is to watch or listen. Hey, Christopher Melcher, we like your filing. We're not super confident in what Judge Penny was going to do, but we appreciate you fighting the fight. I think you're setting up a longer fight between the court system and the media, and we appreciate it. So thank you. We appreciate you. In court, in-person attendance is usually not an option for me because of the distance of the courthouses in Virginia. The number of cases I follow, limited funding for work travel, and health concerns due to the pandemic. Many journalists are similarly situated and cannot attend court in person for the cases they cover, which I'm informed and believed to be true from working with other reporters for many years. It is difficult, for sure, and hearing it is different. I don't like relying on how other people interpret things because, again, not everybody has years of legal experience. It's really hard to really ascertain what happened. And again, people hit on different key points because that's key to them. But also, when you're trying to process information and record information, if you're not trained in doing that, that's also very difficult because you're listening and processing and trying to transcribe. It can be very hard. Not everyone's trained in just transcribing. Court reporters that I've worked with are like, look, I don't think about what I'm hearing at all. I hear it, I type it, and I turn off everything else. They're not processing the information so they don't miss anything. But that's not the case for most people. It's just, Robbie said, a terrible game of telephone. It is like a terrible game of telephone, which shouldn't be how we rely on getting information in cases like this. I mean, that there are so many questions, and there are ethical questions. There are questions of impropriety. There are questions of abuse. There are a lot of questions in this case. Closing the proceedings down more is difficult. USA Today will cover the hearing on September 29th. If remote access is not provided, a reporter will have to appear in person, attempt to find a seat, take notes by hand, relay the information to an editor like the last hearing, and it will substantially limit the ability of USA Today to access the court to gather news and report on this and other cases in the LA Superior Court. I'm informed and believe the same will be true for many reporters. Yep. And commentators. For sure. Request for judicial notice. The request for judicial notice is everything that's filed in addition to this and saying the court can take judicial notice, meaning the court can say these things are true. The court can take judicial notice as true, the transcripts, etc. Thank you for filing it with pink paper in the exhibits, because then look, here's the thing. There's 244 pages of this thing, but it's so easy to see when the exhibits start and stop because the paper is a different color. It is the little things that make life easier, and this makes life easier. So thank you. Thank you for this. I appreciate it. Yay. This includes the notice to attorneys with regard to, I don't know why that, I don't know why that happened. I've never seen my computer do that before. It looks like we're, in a Minecraft house. All right. Effective Monday, January 11th. This is the allowing the RAAP program to happen. It doesn't say in here that it is a temporary program. We're implementing this new tool as part of our ongoing effort to ensure public access during the pandemic and to enforce social distancing requirements. But it doesn't talk about it being temporary. It's the preferred option. It should still be. And it talks about all of the concerns that there might be. Every courtroom maintains at least one available seat for media representatives and at least one available seat for members of the public with prior approval. Excuse me. Any other seats will be available to the extent allowable by social distancing protocols. So it was like, we will make one spot available for observation, but now we have this other way that is safe and that is preferable. And it is. This gets through the user guide for LA Court Connect. We're going to zoom right past that because A, y'all don't care. And B, I know what it says, but LA Court Connect is how the lawyers and parties access like the Zoom that then pops up on the courtroom screen. This is the transcript from the 23rd, and the transcript from the 14th is also in here, which I appreciate. I'm going to zoom through these real quick, and then we're going to go to questions. But we didn't have the 14th transcript before, and I will be going through the transcript from the 14th and kind of highlighting points for Friday that we haven't already talked about, if anything comes up that we haven't already talked about. So for the parties in Department 4 as well as the overflow courtroom Department 1, there will be no photos, no laptops, no phones of any nature, only pen and paper and pencil. If you have that can be used for note taking, which sucks because I take notes when even when I'm at conferences now, I take notes like this. Or I take notes like this. And recordings. And I'm announcing this for the benefit of the parties in both courtrooms, as well as those appearing on RAAP, which is the Remote Audio Attendance Program. Recordings are prohibited of any kind, are prohibited either in the courtroom here in Department 4, Department 1, or the parties appearing on RAAP. There will be no live tweeting, no electronics, and again, no recording of the proceedings is permitted. So I'm going to get the appearances of the attorneys and parties, but the court made it clear and made it clear after break 2. Let's go. There are a few other exhibits. Let's see. This is all of Britney's statement again from the 23rd. And then let's see. The news release with regard. Oh, there's Judge Taylor. All right. PJ Eric C. Taylor rescinds social distancing requirement in all LA County courthouses effective June 28th. This came out June 24th. And this talked about getting rid of the RAAP in addition to some other changes that were made due to the pandemic. But I don't think you can just pandemic your way around everything. Effective June 28th, the court will no longer offer RAAP to listen remotely. And then it talked about the recording. For many months, we have required everyone in the courthouses to socially distance, remain 6 feet apart at entrances and in hallways, elevators, courtrooms, offices. PJ Taylor said beginning June 28th will no longer be required to stay 6 feet apart. I wonder if that is changing. This is the July 14th transcript, which I'm going to go through. We'll pull out anything that we don't know. Yeah. This is getting into Britney's new attorney being appointed and all of the breakdown with that. We haven't had a transcript of that, so we are going to absolutely go through this transcript, but it's an hour and a half and we're not going to do it today. I'm going to summarize that and go through the different parts of it. We know what happened. I would just like to go through the language of it, and then let's see what the last attachment is. I'm going to do this faster. This is a long transcript, so we're going to try to do this a little bit quicker. Oh, there we are. Now I've moved it too much. Oh, why is my camera always... There we go. That's better. It feels better. I'm all moved. Everything's all moved. Let's keep going through this. That's the problem with having a mostly movable setup. Sometimes shit just gets moved. The Judicial Council of California findings are what's attached next that they were asked to take judicial notice of. Again, I don't know if the court will or won't, but it is official findings from the Judicial Council. The court would have had awareness of that. And that's where we're at. So I like the motion. I like the approach that they're taking. I don't know if this will have the RAAP reinitiated before the 29th. I am not confident that will happen, but I think it's setting up a bigger fight between the courts and the media for access, for free speech, for transparency, and for allowing these court proceedings to be open, which is something this court in particularly seems to have fought against. The end of this is all of these media requests. It's not every single one, but these media requests go all the way back to the beginning of this, where the media has asked to record and it's been summarily denied every single time. And you can see every media outlet that you're familiar with filing these and being denied audio and video recording or any other type of recording. I mean, this one is from TMZ. This one is from this one's the top sheet from TMZ, Law and Crime Productions. This one is from Law and Crime Productions. Every single outlet, Story Syndicate, on and on and on. And you'll see these from People in USA Today and everybody else. This one's the People magazine one. So on and on and on. Let's get to questions. I have questions. You have questions. We have questions. We actually have time for questions today. Oh, and don't forget to do the YouTube things, the likey, subscribey things. If you're subscribed, join the chat, say hello, ask me questions. Let's talk. And we don't have to just talk Britney. We can open for questions. I will be focusing primarily on Britney questions because that's on topic. But I know there are, yes, I will be trying to focus primarily on Britney topics, Britney questions because that's on topic. But I get it. I have questions. You have questions. We have questions. So let's get to questions. I'm going to try to sweep some of the super chats. Thank you for your support. I always appreciate it. For the channel members, there will be information coming out today about the launch of Patreon. For everyone else, there will be coming out information about Patreon will be coming out shortly. The members have first access to it. They can change membership levels. But we talked about it in the members only live stream too. So more information about that. Let's get to super chats. This one is the first one I see, so we're going to do it. Thank you. You're welcome. You are welcome. Joyce Dahl said, I'm happy to see that this is from a legitimate news source and not TMZ, so we know Mr. Spears has nothing to do with it. Christopher Melcher, too, in his commentary on this case, has also asked a lot of questions and has worked in family law and worked in these courts, too. So it's really nice to see this coming from somebody who's intertwined and then has actually had input, and this was discussed briefly on Twitter yesterday, has had input from other accounts that have been following this case really closely. And I like seeing a lawyer reaching out and saying, hey, there are people who've been following this for years. Let's get some of that input too. So super chat from Lex. Why couldn't courts allow like a link for remote access for news stations, commentary, etc.? That one would have access through specifically official/business means and could easily be confirmed. The RAA program needs to be available to the media and the public. So you can't just allow the media access and not the public access. So that's why. Could they do more technologically? Sure. Will they have the money and the ability to do that? No. It's a complex program already to allow remote access into courtrooms. It's a new program. So I don't know how much they've been able to shut stuff like that down. So, yep. Conformist 138, I hope that answered your question, by the way, Lex. Conformist 138 said, why does the court prevent live streaming or recording? Recording seem more accurate than playing the telephone game with written notes. Different courts will deny things for different reasons. Sometimes they want to protect the safety of witnesses. I can appreciate that. That's not really the case in the Britney case. Everyone knows the parties involved. So that's not really the justification. Some courts don't want, I mean, audio recording seems to be the natural thing to not have people's faces blasted. And you can have people testify by their, witness one, witness two, or first name and last initial. There are a lot of options there, but sometimes courts don't want cameras in the courtroom. They think it's disruptive to the proceedings. They think that the media can be disruptive to the proceedings. But the argument that you have these giant TV cameras lined across the back of the courtroom is just not the way it is anymore. And I think some judges are nervous of the speculation, are nervous of the kind of the Monday morning armchair quarterbacking that happens when all of us sit and watch what they're doing and comment on it, and don't want to be open to that kind of scrutiny. I don't know how much that plays in. That's not a valid purpose, but I think that there is some of that plays in. I think also that with regard to Britney, there are things that should be private and confidential with regard to her mental health. Like, her dad's blasting it in all the motions now anyway. But there are things that shouldn't be publicly available. There are things that should be allowed to be private. But these hearings that are coming up, you can do the stuff that's private first and then do the public stuff, or vice versa, do the public stuff and then cut it. Because the hearing with regard to James Spears, we all want to know. We all want to know what the court's going to do, and we want to hear the arguments, and we want to hear how the court rules and why. And if the court's really worried about ruling on the spot, then take it under advisement, take it under submission, and issue a written ruling later. There are a lot of options to get around it, but that is my, again, speculation. I don't know. This didn't come up a lot with the judges I worked with. We didn't get a lot of requests to record. We would get the public coming in and watching, but we didn't get a ton of requests to record because we just weren't dealing with cases that people were that interested in. And the one case, when I was in civil, the one kind of high profile case had a bunch of witness intimidation and juror intimidation going on. So that was shut down for a whole other reason. Catch 22, super chat, thank you, in honor of Overdose Awareness Day. I did not realize it was Overdose Awareness Day, so thank you. You have made us all aware. Psycho Encyclopedia. I think we're going to go with that. My brother learned to read at age 2. Can you imagine explaining these to a child? No. Piss and Vinegar said someone who is a Jaren should say, I'm a Karen. Someone who's a Karen should say, I'm a Karen. Maybe. I think that's regarding the license plates for sure. Tiffany Leeson said, we have a case like this in Canada. It is his last name, Grab Her, like Grabher, like grab her. He had it for 30 years, but they won't renew it because it's considered offensive. There was one that was in my hometown that was Fister. I imagined it was a last name, but the license plate just said Fister. And every time I saw it, I was like, it always made me giggle. I'm like, Fister, your license plate says Fister. Wow. Question. So what is up with this judge? Does she not care about how she is being perceived? I don't know. If I were here, I'd remove Dad Spears just to shut everybody else. If I were her, I'd remove Dad Spears just to shut everybody up. Not a valid reason for a judicial ruling. There has to be valid reason. But I think that I really do think that Matthew Rosengart has laid out the grounds for this being, for James Spears' removal being in Britney's best interest. And I think it's going to be very hard for the court to ignore that. And I think the court is going to sidestep around it and try to maintain the status quo a bit. And I think that what everybody wants to see is the status quo not being maintained and seeing this, seeing James removed on the 29th. I worry that we're not going to see it and that the court might take it under advisement so that the court doesn't have to be in the spotlight doing this and can issue a written ruling, which might be the most appropriate if the court issues a thorough written ruling as to why the fuck they're doing what they're doing, because the court's already denied one motion to yeet Dad Spears. Mother Oats question: can you do a collab with Christopher Meacher and or BJ, that surprise witness? I think we should definitely do a panel. I don't know when I would schedule it because I'm going to be traveling a ton in September, but we should absolutely do a Britney panel. The thing is, whenever I do interviews on this channel, y'all don't watch them. Let's be honest. Y'all don't watch them. But we can. Absolutely. I think it would be a good panel. Question: is there concern that the CPA is stepping down due to conflict? Shits and giggles. I've seen that being asked on Twitter. I've not seen any court documents regarding it. Question: is there anything Rosengart can do to potentially get a new judge on the case? Rosengart could ask the case to be moved to federal court. Rosengart could try to find a conflict with this judge, but it would be hard because it's way late in the proceedings to do that. Bringing on a new judge could also delay things substantially. I think trying to get James Spears gone is step one. There's phases to this. Everything's not going to happen at once. It is going to be step by step by step. And getting rid of James Spears seems to be the focus of step one. And then dealing with, should this be in federal court? Should this stay here? Should they see if the judge has a potential conflict of interest? That might be hard. But can they? Yes, there are things that can be done. Is that their best tactic at this point? I don't think so yet. I think they have a very strong argument for getting rid of James and then going and dealing with it. And then starting the investigation into what's been going on for the last years. Julie, this is a good question. Can Britney legally write a will? No, she cannot. But I believe there's a trust in place for her based on other documents that I have reviewed. And there would be a living trust and a will and other estate stuff that would have been done long ago, just based on her celebrity and her wealth. But right now, if something happens to Britney, the conservatorship has the estate in the conservatorship, and that would become a different type of probate estate, but the estate is still an estate. So it's in probate court, the same court you would deal with if something happened to somebody, and the estate would just stay there. So Ario Scorpion, thank you for your ongoing passion and willingness to educate us, and thanks to your mods for their time and efforts. Our mods are fantastic. So thank you for the love to the mods. We appreciate it. And thank you. I love doing this stuff. And I love trying to help people understand why the courts do what they do, even when we don't agree, because asking questions is critical, and understanding even when we don't agree is like next level critical thinking, being like, I see why this is, but I hate it. I see why this is, and I want to change it. It's a hard thing to do, to take your emotional side out of, I fucking hate this, out of it, and trying to go, what is it? What are the facts, and how do we move forward? And that is a difficult thing to do. And I feel like sometimes not always encouraged. So we encourage it here. We encourage questions and conversations for sure. I'm actually pulling up the Britney case. I just want to make sure no new documents have come out. Do we honestly think that Judge Penny is bad? I don't know. I don't know. I have questions. Why nothing happened from 2019 to now, why the previous motion to remove James was denied. I have questions about some of the thought process there, but also the judge has more information than I do. So the judge has more information than I do. No new documents that are available on the public website yet. And I don't think there will be any today. I think we got to this. Why is it so bad to record open court anyway? Why do the judges always object? Today's cameras aren't intrusive or disruptive. There are other concerns for sure. I think some of those concerns, again, as I mentioned earlier, don't apply in this case because we know who the parties are, right? There are cases where I definitely wouldn't want the witnesses' faces to be recorded and memorialized and put out there forever. I wouldn't want the jury's faces recorded and memorialized and put out there forever. But there are ways to do things with boundaries. And we've seen that in other high profile cases that have gone to trial and been recorded in recent months. So there are ways to work with this. It also depends on the judge's willingness to do it. And I think this is a case that is demanding transparency. And Britney has said through her previous court appointed attorney that she wanted this case to be more transparent. Sierra, what is the process to become a judge? Oh, that is a much more in-depth question. But to become a judge like Judge Penny, we're just going to go with that. To become a judge like Judge Penny in California, you can either be appointed or elected. You have to have 10 years of legal experience and be a member in good standing of the bar. And then you can either run to be elected or you get appointed by the governor. And then when your term is up, you run to be elected. It's something that friends of mine are getting ready and gearing up to go through because they've all kind of reached that threshold of years of practice and are ready to ascend to the bench, if you were. But yeah, it's mostly an elective process. At some point, it's always an elective process for the Superior Court judges. Ignacio said, you mentioned 2 days ago to get 2 days is not. Let me just start over. You mentioned 2 days to get a jury is not enough time. What's the average time to gather a jury then? I mentioned that I thought in the Theranos case that 2 days might not be enough, given the length of the questionnaire. And this is why I said that. The length of the questionnaire, the potentially highly impacted jury pool, because again, the Elizabeth Holmes trial is taking place in the court that's essentially in Silicon Valley. So this is the way that the Girardi scandals rocked the legal world. I can't imagine there are many in the Valley that have not heard of this case, followed this case, been fascinated with this case. So you're going to have a jury pool that might already have some knowledge of the case or some bias with regard to the case. That's okay for the average person walking around. It's not okay for a juror. So trying to find individuals, that's going to be challenging. Also, just for my friends that are in trial now coming off of COVID, they're getting about a third or less of the jurors that are supposed to show up actually showing up to court. So they might just not even have enough people once you start excusing people for cause, which means the reasons you're allowed to excuse jurors. Once you excuse people who are like, I worked there, I worked with someone who worked there, I know her, I know this, I lost money. Once you start excusing people who cannot sit on the case, they might just not have enough people to put a jury together, which is why I think in this environment, for this case, in this location, with this amount of publicity, 2 days is probably not enough. That's probably way more of an answer. But that's why I think it's going to take more time. Though it is a federal case, and they're also only running court till 2 p.m. They're running court from like 9 to 2, so people don't have as much exposure in a courtroom with regards to the vid. Since apparently I'll just get like all of the bad, I'm going to get all of the bad juju today anyway for the algorithm because I've said all of the things with those license plates. So all of that's going to happen. So we're just going to go with the vid. I think I've already said the full name. Whatever. Algorithms be damned. Law nerds, just say it how it is. Question. So what's up with the judge? Oh, we did that one. Perfect. It was such a good question. I just wanted to answer it twice. Sophie Sanity. Question. Even if or when the media request is denied, will Britney's case remain open for a small group of the public and media in person, or has the September hearing been sealed? It's open to the public in person. So people, again, have to go to court, get in line up, get a spot in the courtroom, all of that. So it is open to the public, but it has to be in person. That proceeding has not yet been sealed. Question. Would you have been happy to have your cases be accessible like this? Like as an employee, how would you feel about the public scrutiny when you're doing your job? Lena, this is going to sound petty. I would have been more concerned about the scrutiny of my looks, my voice, my demeanor, the size of my ass, because those are the things I heard on jail calls about myself anyway. I would not be worried that someone was going to see me doing something that wasn't my job, because we saw how brutal the media was to particularly female lawyers in different high profile cases. It was not comments on their arguments, their intelligence. It was comments on the hair, the shoes, the clothes. So that kind of scrutiny would have been hard. There were definitely cases that I worked on where there was a lot of scrutiny within news and print media. Not that the media was critical of me, but that an article about the case would come up, and then the comments section would be critical. The only reason I monitored the comments section is because of potential witness intimidation, and just to know what might be coming up in court, because court is open. Those types of things I wouldn't be here for. It's kind of like, I don't know, putting yourself on the internet in a hostile environment where you don't get to control the angles. Look, man, I like this angle. What I don't love this angle. Sure don't. It gets worse. Like, the lower down you bring the camera, the fuller the chin looks. We don't love it. So there are some vanity considerations that I wouldn't have loved. I definitely looked exhausted by the end of trial. There were some cases where I did have witness safety issues. I would have had big concerns about those, but those were limited. So it's just part of it. But it can be hard when you're trying to do a case when there's a lot of external eyes on the case. And I saw that with one of the DAs I worked with during some of the low-hand prosecutions. We were in the low-hand stuff was going on, and we were in the middle of a murder case that was a very, very important case to us as prosecutors, and a very difficult case with a lot of witness intimidation and a lot of other issues, like fights breaking out in the hallways of courtrooms and death threats and stuff like that. So that would be a lot to deal with. But again, when it's your job, you deal with it. And you maybe don't joke around with defense counsel if you're being recorded the same way that you normally would in a closed courtroom. I agree with that. Question: was the milkshake song ruined for you after that day? No, Laura M, it wasn't. I still love it. It's no longer my ringtone. I was never more embarrassed. The judge and I worked together quite a long time, and he had a good sense of humor, but the look was like, these fucking kids. It was just like, Baker, what are you doing? He was also the judge when a defense attorney and I, who I actually like and still to this day like, and we got along better after this, but we got into it because he was making the most ridiculous argument, and I actually burst out laughing. Shouldn't have, couldn't help it, was so tired, was so frustrated, was so angry. Sometimes my inappropriate response is laughter, like big angry displays of emotion. I will laugh. I don't know what that is. That's me. It just, I can't always. And big angry display of emotion over something ridiculous. And I was just like, oh my God. And we got into a yelling match. The judge was very patient with us. Yeah, there were days. There were definitely days. So yeah. Rachel Mills, the Chauvin trial was shown and recorded. What's the difference between that versus this? That judge allowed it. This one said no. No difference. No difference. There's no jury in this case. I think there's less room, as I'm like moving things around and being loud, I think there's less room for prejudice or problem in this case because there's no jury. Like there's not a criminal defendant. There's not someone going to prison. There's not someone who's been killed. There is someone who's been very harmed, and that person's Britney, but there's no potential risk that the media reporting is going to bias or taint a jury pool. I think this case is more appropriate to be open than criminal cases where you can have jurors watching things in the courtroom that happened that maybe they were excused for, stuff that the cameras caught, sidebars, motion arguments, evidentiary proceedings that the jury was removed from the courtroom for, but the jury's not supposed to be watching TV. I think there's more of a risk there than there is here. Because again, the motion pointed out, and it is just a practical matter, of course, you can shut down the audio or close the courtroom for sensitive items. That's not hard. Lawyers know how to not argue sensitive things when they're not supposed to. Just like the housewives know when they're being recorded and when they're not, and what shit to bring up to stir shit up and what to not bring up. And you can see the anger. It's like, I can't believe you said that. It's not, I can't believe you said that. It's, I can't believe you said that while we're rolling. So The judge is the difference, Rachel. That is a long way around. Questions, wondering your thoughts on the Real Housewives of Salt Lake City trailer. Oh, I am going to be recording an Emily Reacts for the Patreon about that. It implies that Meredith had something to do with the feds coming after Jen. I think that's bullshit. Also, Jen makes a joke about hiring Kim K, not taking the charges seriously. That's what I got from that, but it's edited. I think that Jen is following the Teresa Giudice playbook and blaming a co-star. The feds have been onto this case for years. Jen Shaw was already deposed by the FTC in another case that she lost. I have a podcast about it, the episode where I cover the dry contact defense. There is a substantial history with this case in the feds. I need to see what she thinks Meredith did, because it's not Meredith that brought Jen into this case. I suspect and would not be surprised to find out that one of the many co-defendants that has pled guilty in this case said, oh, by the way, you might want to take a look over there. That's how the entire college admission scandal came down. All of Operation Varsity Blues came down because one dude got popped by the feds for something. I don't quite remember what. Could be taxes, could be bribery, and said, yeah, I know you're interested in me, but let me tell you what's going on behind door number 2. And it busted open the entire college admission scandal. So is she implying that Meredith has been investigated by the feds and was like, let me give you Jen's business that none of us understand? No, I think she got looped into this by co-defendants that pled guilty and snitched. That's what I think. So we talked about that one. I'm going to keep going. Did we get to this one? Tammy Johnson, did you see the battery charges against the housekeeper? Went to the DA yesterday for possible charges against Britney. Thoughts? I mean, it's a misdemeanor in LA. I don't even know if it will get filed, but that's the proper course of things. And what we don't want to see is people taking different courses of action because somebody's a celebrity. So a police report was taken, a call was made. That is the proper course of business. Off topic, Gibbers King said, since you offered, I'm surprised and intrigued that TMZ has not followed Prince Harry and Meghan Markle. Any knowledge or thoughts on this? No, I haven't thought about it literally at all. So no. Celeste, was the audio access available internationally? I don't know why it wouldn't, because it was a feed. It was an internet feed. So you signed up in advance, then you got permission, you got a link, you went to the website and listened that day on a web feed. So I imagine you could access it anywhere. I don't know whether the court would grant access anywhere. So I don't know. It never came up. Why doesn't Judge Penny ask how TMZ knows things ahead of time? I don't know. And maybe Judge Penny does. Judge Penny certainly asked about the New York Times leak, but did not ask about TMZ. TMZ does, but TMZ also speculates on things early. I think they probably have the filings early, and then the filings are filed. So I don't know if the judge can do much about that. So Sneak said, I sent a Supak question before. I did not see it. Hold on. I'm going to go make sure that it's there. I did not see it. Let me see why I don't see it. It doesn't show. The reason that I didn't answer it is because I don't see it in the back end of my YouTube when I went to go pull it up. So where can I find your answer to when you addressed where Biden was mentioned? That's the only super chat I see. So apologies. I try to get to all of them. I don't always. Can Biden write an executive order to overrule the court system in California? No. That would be an overreach of federal powers. The court system in Biden has other things to deal with, but the court system in California needs to govern itself. I would not like to see the federal government trying to intercede in how courts do things. The courts in California can, the California Supreme Court can, the California legislature can bring stuff up, but I do not want to see the federal government trying to get in on that. So hopefully that answered your question. Judges get used to being above scrutiny in their own courtroom. Amy, I think that's true. And I think that's true for a lot of professionals. I also think it's hard sometimes when people outside of the system are looking in going, well, why are you doing that? And they're like, oh, this is how we do things. But I also think the court system is supposed to be open. I can admit, I get frustrated sometimes when people are like, I don't care what the court says. I don't care what the law says. I think it's this. I'm like, you are missing the point of literally me. But okay. So I can see why the courts would maybe have a push-pull with this, but also it's always been open to the public. Anyone can walk in. I think the difference for judges and the difference for anyone online is when people walk into your courtroom, you can see them and they can see you, and you know who's watching and you know what they're watching. You don't know when it's just this recording, but that shouldn't matter. Viva Jess said, to the mod that chastised me for over exuberance using caps, it was expressly punitive. I unsubbed. It's a shame. They were all such positive comments. I haven't seen that. It might not be a sub because you know what? I have Nightbot set because all caps are difficult for me. And I make that very clear in all of my content. So I'm sorry that you feel that way. All caps are difficult for me. Nightbot is a bot that I have set to turn off all cap comments because they are difficult for me. Love and One, is it unlawful to charge to have virtual access? I don't know why it would be. There is a waiver fee. It's the same with court documents. It's not unlawful to charge the processing fee for court documents. Look, they vary wildly in how much court documents are charged for. On Pacer, the federal court documents are like 10 cents a page. In Nevada, they are 50 cents a page. 50 cents a page for their processing fees. LA's are they 25 cents a page? Yeah. So it varies widely between court process, but no, it's not unlawful because those are going to be the court can't bear the cost of making the thing accessible. So that's an administration fee and they're allowed to do that. They've waived it for now, but they're allowed to do that. So we answered that. Question, yes, we talked about that earlier on, Daisy Dottie, and I have an Emily Show episode coming up on that tomorrow. So that will be available. We did that. Oh, I got behind. Apologies. If Judge Penny denies the motion to yeet, can it be appealed? I mean, will it be or can it be? Can it be? Yes. Will it be? I don't know. The thing with appealing it is then there's no remedy because it's for the 29th and there's no remedy. There's no remedy after the 29th. But what I think they're trying to push is to get the court to rule on the program as a whole. And then that can be appealed with remedy if the reasoning behind yeeting the program is actually being able to, if they actually give the reasoning, then you can attack the reasoning on what they're doing. Hopefully that makes sense. Lee Heathers, I like watching people interviewing you. Emily, thanks. You are a fun guest on other channels and give great legal answers. Well, thank you. I tend to do interviews OPP on other people's platforms. There's a playlist here of the other channels I've showed up on, the other places I've done panels, collaborations, panels and other videos, collabs with vidIQ and stuff for different topics that don't always fit here. So, Milton, can't you skip the Congress? You would be reliable. A reliable source for the 29th court date on Britney's case. P.S. Thank you. Conference. Oh, thank you for making the law understandable for everyone. Love from Argentina. Thank you, Milton. I am speaking at the conference. It is Vid Summit. It is a very large creator conference with Mr. Beast and Mark Rober and others. So if it were any other day, I would have gone early to get to the court date and gone, but I will be following the news and I will be bringing I have not figured this out yet. Tech and I are going to have a conversation about this later, but I have not figured out what equipment I am going to bring so that I can try to stream from the hotel. I need to reach out and ask like the other fancier YouTubers if they're going to bring streaming setups so I can just use theirs. I'm going to start reaching out to people. Hey, I'm going to need to stream. Who's bringing streaming shit and make it work? So yes, I'm not going to skip the conference and yeet down to downtown LA, but I will be following along with the news and taking care of it. I've seen this question a couple times. Doesn't Britney live in Ventura? Yes, it could be moved there. Oh, it's moving counties at this point might not make sense. Moving court systems might, because this case has been governed so long in LA. I don't think that would be granted just for difficulty. But yes, she does live there now. She did not when this started. Eric says, I heard the case was being moved to Ventura. The criminal stuff, the forwarding to the DA and stuff, is in Ventura. That's not in LA because she lives in Ventura, and that's where that happened. So that would be in Ventura, but the conservatorship is in LA probate court, and I don't see them moving counties on that. So I'm going to try to get to a few more questions to see what we can. Question: when is the fall Larnard collection dropping? Emma, I have not set a date for it. Soon. I am waiting for my samples to come in to make sure they turned out good. Once I get those in, then I will set a date. I'm hoping, don't hold me to it. I'm hoping for the 15th of September. That is my goal, but we will see. So that is the goal. Thank you for asking. Question: if the judge does not remove Dad Spears, what would Rosengart's next step be? At what point should he go after the judge? Well, he would move it probably out, or try to move it to the federal court system before, but we will see. I'm interested to see what happens on the 29th before I speculate any more on that, because his next step might be to try to terminate the conservatorship in its entirety. It's like, fine, you're not going to get rid of it. Let's just terminate the whole thing. Make the court go on the record. But this 12th accounting has been pending for like a year. So things are not moving quickly in this court. And I think a lot of us want to see it move more quickly. And we're just waiting. Like, tick tock on the clock. Yep. I'm going to do 2 more questions, and then we are I'm going to have to yeet myself because I have a lot to do today. We have been live for over 2 hours, and I can tell that my throat is starting to get tired. Question: hello, Dr. Riley. For recording devices in the courtroom, is there a major concern that microphones could pick up lawyer-client confidential whispers? Always a concern, but not as much of a concern when they are on Zoom and can mute themselves. So they should be able to communicate in other ways during the hearing so that they can mute themselves on Zoom, because if they're on Zoom in different locations, they're going to have to figure that out anyway. So though that could sometimes be a concern, that is not a concern right now. If that makes sense. Question: how could Judge Penny not remove Dad Spears? I agree. She already did it once. What more does she need? If she's persuaded by his side that there's no cause, but there doesn't need to be cause, I personally don't know how she could deny it. I would need her reasoning if she does that, but that is speculation because that has not happened yet. So I don't know. There's a lot there. Mona Montgomery said Penny was elected unopposed. That happens quite frequently in LA. That's not surprising. That happens quite frequently. So, all right. Snicks, where can I find your answer? I answered it. I answered it up above, so hopefully you heard it. I don't know exactly the timestamp because I don't timestamp super chats. Would you ever do an episode on cases you have done, funny moments? I tend to do those in the members live when they come up. So yes, when it comes up, I don't know if I would do an episode. Maybe I will. Maybe I will see if I can find some of the other DAs that have left and have a bigger conversation about funny moments. There is a DA who tried a Mattel case with Barbie scaling the Mattel building that is also kind of funny. Amy said, speaking of sexist comments, the senior partner male and senior associate attorney female, and I tried a huge case and won. The newspaper praised his performance and made sure to only comment on our shoes, picture included. Right. When does the judge have to rule on the USA Today filing? When she feels like it. It is a motion that is brought outside of a regular pleading schedule. So I would have to check the California Rules of Court or the LA Rules of Court, but she can rule on it when she wants, hopefully before the 29th or hear it on the 29th. But again, I wonder if the judge is going to try to get around this by saying, I have no control over RAA. That needs to all go to the PJ. So, yep. Gabby, I will go look at it. I don't know if Ahmad put you in timeout for that. I would have to look. I understand. Matt Bond, boop de floofs. Good to see you, Matt. I will boop de floofs for sure. Thank you for that. Are you going to cover the judge's ruling on the latest Depp Heard dismissal attempt? Yes, I will. I just have not had time. But yes, I absolutely will. All right, y'all. Thank you so much. Mods, thank you very much for a wonderful stream and for all of your hard work. I appreciate you. Hey, Nightbot, being sassy. I program Nightbot. Tech help me. Nightbot is a little sassy, but Nightbot helps me stay on track when we have 3,000 plus people in chat so that I can get to as many questions as possible and don't have to go to a super chat only, which is something I definitely don't want to do. I don't want to be like, oh, I answer super chats and nothing else, or oh, I answer members and nothing else. So some of the things that I have in place are so that I can answer for everybody and try to answer super chats and members and non-members of the channel, because I know not everybody can afford or wants to afford paying to have a question answer. And I really do think law should be accessible, and I'm trying to keep it that way. And things like Nightbot help me keep it that way so I can answer as many questions as possible to try to make the law process accessible and more accessible than the LA Superior Court system, apparently. We will continue covering this here. I will be updating you on the socials if stuff happens before Friday. I can't see a circumstance when there would be an emergency law nerd meeting this week because my week is slammed. So if you want to keep up to date on things, if you're in North America, the text crew, textemily.com. That is a great place to stay up to date on all the things. Emily D. Baker, the Emily D. Baker, all over social media for the kind of late breaking stuff. Faster on Twitter, not as fast on Instagram, but that's where those things live. And what else? That is everything. For the members, information will be coming about the move to Patreon. I appreciate it. Oh, Ashley Vincent, yes, we are. COPO keeps getting bounced because I just have not had time. So thank you. All right. Thank you, everybody. Thank you for being a law nerd. I appreciate you. And I will see you in the next one. Have a good one. Take care. Stay safe. More wild weather. It looks like ours is starting to clear up, and I hope yours is too. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just textemily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.